Are non-compete clauses ethical? Imagine working hard at a company, then being told you can't work for a competitor or start your own business in the same field after you leave. That's what a non-compete clause can do. These are agreements that restrict employees from working elsewhere for a set time and within a certain area after they leave their job. From a legal point of view, these clauses are meant to protect a company's trade secrets, confidential information, and reputation. Employers say they help prevent unfair competition and protect investments in employee training. But the big question is whether these restrictions are fair to workers. Courts usually look at how broad these clauses are. If they last too long or cover too large an area, they might be considered illegal because they unfairly limit a person's ability to earn a living. For example, a non-compete that stops someone from working in the same city 4 or 5 years might be seen as too harsh. Many states, like California, have laws that make non-compete agreements invalid because they believe workers should be free to pursue their careers. Other states enforce them, but only if they are reasonable and only apply to employees earning high wages or with specialized skills. The main ethical concern is whether these clauses are fair. They can make it hard for workers to find new jobs or start new businesses, which can lower wages and slow down innovation. Lower wage workers or those without special skills are often most affected. This raises questions about fairness and whether it's right to restrict someone's ability to work just to benefit a company. Recently, the Federal Trade Commission proposed a rule that would ban most non-compete agreements across the country. This move shows growing concern that these clauses can hurt competition and workers' earning potential. From a legal and ethical view, non-compete clauses are okay if they are narrow and only protect real business interests. If they are too broad, indefinite, or used against low-wage workers, they are often seen as unfair and unethical. The key is whether they balance protecting a business and respecting an employee's right to work. Employers and workers should carefully review and negotiate these agreements to make sure they are fair and follow the law. When done properly, non-compete clauses can be ethical, but when they are overly restrictive, they can unfairly limit a person's work opportunities.